Okay, we'll now take up case number 22-741, City of Gulf Breeze versus Brown.
May it please the court and Mr. Levy. My name is Ed Fleming, and I'm here today with Ms. Lindsay Miller-Haley assisting, and we have the honor of representing the petitioner in this case, the City of Gulf Breeze. Thank you for accepting cert on this case. We understand you're a court of limited jurisdiction and that we do not have a matter of right to appeal this case. The court below considered it to be an issue of great public importance. This court agreed and granted cert. Thank you for doing that. The issue before you here today is not whether a spray field is a municipal use or a golf course is a recreational use. The issue is not whether those two properties continue to be used as a spray field and as a golf course before and after a private management company was hired. The issue is not whether a private management company, a private for-profit management company, destroys the immunity. The court below, in fact, the majority went to great lengths to correct the dissent in saying that's not what we're saying. We're not saying that the existence of a for-profit management company managing otherwise exempt uses defeats the immunity. So the issue today is very narrow, and that is whether the method of computing the profit for the for-profit company destroys immunity. And we would respectfully submit there's no precedent, no authority, no logic, no public policy that would support doing so.
Counsel, can we take it as a given, based on the record here, that there's no dispute that under this management agreement that the city was still ultimately in control of the use of the property? You know, the first DCA had the profit test. If we want to sort of clarify what is kind of the relevant consideration here, it seems like in terms of deciding who is quote unquote who's the exclusive user of the property, it seems like the control thing is a big part of it. Should we take it as kind of undisputed that the city is the one that controlled the property? Yes, Your Honor, it was undisputed. The depositions, the testimony by all of the witnesses, both before the Value Adjustment Board as well as before the Circuit Court, established that while the city personnel sat in the seats of the management office, that it was controlled by the Director of Recreations, Mr. Ron Pulley, I believe his name was. And that after the private management company took over, it was controlled by Ron Pulley as Director of Recreation. It was control did not change, purpose did not change of the use of the property. The only thing that changed is you had a contract manager under a management agreement versus city employees sitting in the seats taking directions from the city as to how to use city-owned property for what everyone admits were municipal and public purposes, i.e. a spray field for disposal of groundwater from wastewater treatment area and for recreational use for the golf course.
I wonder if we could go to the text of the Constitution for a moment. So Section 3A says all property owned by a municipality and used exclusively by it for municipal or public purposes shall be exempt from taxation. Can you walk me through your reading of the words "and used exclusively by it for municipal or public purposes"? Clearly, your last answer says the control of the property didn't change. Did use of the property change in that a private entity, and let's leave aside that the mode of compensation for the private entity. Let's assume that is irrelevant to the analysis. If a private entity is also using the property to make a profit, how that squares with the text of the Constitution?
And, Your Honor, that is exactly the analysis. That's before you, of course. You look, as this court has pointed out many a time, you give effect to every word that's used in the Constitution. That was not done by the property appraiser in his briefing. I would note that no less than 6 times that phrase that you just quoted, used exclusively by it for municipal or public purposes, was cut off after the it. It didn't say for municipal or public purposes. And so it's used by the entity for municipal or public purposes. How did the city use the property? Not whether a third party may have benefited. You know, you could have vendors of golf balls who benefited. You could have a for-profit electrical company benefited from selling power to them. You could have someone who rented golf carts benefit.
Your reading of the Constitution then is as long as the city is using the property for municipal purposes only, then it is ad valorem exempt. So does that analysis cause the leasehold interest discussion to drop out of the equation, for example? Could, you know, as long as the city is using the golf course for municipal purposes only, would it be free to enter into a lease agreement?
Your Honor, I think a lease agreement is analyzed under a different standard. And that's
why is that?
Well, because a lease gives a estate and property to another person. And so
if the vending machine company had a leasehold interest, then your position would be the golf course is no longer exclusively used by the city for municipal purposes.
No, Your Honor, because you can have ancillary uses. You know, you can have a drink machine in a public park. It doesn't destroy the immunity for the public park because it's an ancillary use. You can have a pro shop that's a supportive of a recreational golf course. It doesn't destroy immunity. You can have tennis pros at a city-owned.
Isn't the real question if this management agreement had been converted into a lease, and the same sorts of things are going on, but there's a leaseholder who has that possessory interest and all the other things that go with a leasehold. In that context, wouldn't it be your position that it really makes sense to say that the leaseholder is the entity that is using the property, as opposed to your circumstance where there is not a leasehold, but there's simply a management agreement in which it is the city that is using the property?
Precisely, Your Honor. You know, when you give someone a lease to real property, you're basically saying you can act as the owner for this property, with the exception being your ownership expires at the end of the lease duration. So a lease completely changes the dynamics of this, because a lease transfers a portion of the ownership, part of the bundle of sticks that we talk about in law school all the time. It gives part of that bundle of sticks to the tenant, and the tenant looks like the owner in many, many ways during the tenancy of the property. Here, that didn't occur. Judge Makar in his dissent, and I understand it's a dissent, and of course a dissent isn't precedent, but they dissent when the court is being reviewed by a superior court, can be looked at and often becomes the majority opinion, you know, if this court agrees.
That's what you're hoping for.
That's what I'm hoping for, Your Honor. I think the dissent, like all petitioners, I think the dissent was brilliant. and very well done. Justice Corral, you absolutely hit on the issue, is you have to look at the entire language, and it's the use by the city, the municipality, not the use by a third party that's important. Did the management company hope to make a profit through managing the property? Sure they did. But the control of the property remained with the city, and it was used for the very same purposes it was used when the property appraiser said it's exempt. It's exempt. So what changed? I mean, we talked to the deputy property appraiser and said, what changed? And he said, I don't know of anything that changed. You know, they sprayed brown water on it before. They sprayed brown water on it now. They played golf on it before. They play golf on it now. It was under the control of the city before. It's under the control of the city now. So what changed? If the fact that a management company can make a profit doesn't alter the dynamics, and the majority below said
well, you would acknowledge that in some of the case law there is this talk about profit making, isn't there? That's a bad thing.
In some of the older cases, there is. In the newer cases, it's the management companies are recognized as, sure, a private management company is going to be in the business of making a profit. And they can also have losses. So what did the majority say was differentiating? They said if you paid this management company a fixed fee and that their profit was determined by the difference between that fixed fee and their cost, that'd be okay. So, for example, if the fixed fee was $1 million, and their costs were $500,000, they'd have a $500,000 profit. But if you have a variable source of revenue, such as an encouragement to the management company to maximize the use of the golf course through green fees, a good thing for the public, maximizing the use of the recreation, then that defeats it. But neither one of those changed use by the municipality of the property. The use remained unchanged, and I think that is the critical point before the court.
Is it relevant at all that the management agreement purports to set out that the contractor shall pay any ad valorem taxes? Is that relevant to our analysis at all?
No, Your Honor. You cannot change by contract the Constitution of the state of Florida. The contract could have said this property is immune pursuant to Section 7.3a of the Florida Constitution. Would that have any effect? Zero. The city could have purchased an insurance policy from Lloyd's of London saying that if this property is ever taxed, you'll reimburse the taxes. Would that change the immunity analysis? Not at all. The rationale, the rule, and this court has held that unlike a lot of exemptions where the exemptions are not favored, they're strictly construed, the exemption for municipally owned property has just the reverse. It's presumed to exist, and it is the burden of the property appraiser to defeat that presumption. The rationale behind that rule is very simple, is that taxing government is bad policy. That issue was discussed in the case of Rosa versus Micos, which was cited to in this court's decision. That cite came in the dissent, by the way. I point that out. But it was Florida Department of Revenue versus City of Gainesville. And why is that bad policy? Well, you shift the tax burden from the county. The county's taxes base would increase by taxing this property, and the city residents, their tax base would increase as a result of this. And that shifting, each side should pay their own taxes, and one government shouldn't tax another government. That's the philosophy behind that rule, that it is presumptively valid. Now, if the municipality goes and builds a hotel for profit, that defeats the immunity. Why? Because building a hotel is not a traditional municipal purpose, and making a profit from a hotel is not a public purpose of a municipality. That's the reason it's defeated. But it's been established, and it's not even disputed in this case, that operating a recreational golf course and operating a spray field for the environmentally sound disposal of groundwater are municipal purposes traditionally, such as the utility, and by case law, the operation of a recreational facility like a tennis court, like a golf course, and a marina are deemed to be a public purpose.
Can you help us, though, with the test? I think we know from the sort of where this language in the 1968 Constitution came from that there had been prior case law that said that, a private entity could use its property for a municipal purpose, and things could be exempt, so that the Daytona Speedway thing. So then the language comes in and it says used exclusively by it. Right. And you've been kind of focusing on the municipal purpose part, which it really isn't the disputed part. What if you were how do you want us to articulate what the test is for when the property is used exclusively by it, i.e. by the municipality? Because we know it doesn't mean literally used exclusively by it, because the public comes and plays golf there. Sure. And whatever. Sure. So what is the test?
I think you would concentrate on ownership and control. Who owns the property? Who owns all the property? They haven't given part of their ownership away through a lease. And who controls the property? Is it owned by the municipality? Is it controlled by the municipality? And is that control exercised to accomplish the municipal purpose of a spray field, the public purpose of a recreational facility? I think that's the test, and that's a test. I think this court went to great lengths in the Treasure Coast case, going well beyond what you had to do, looking at case after case after case that have addressed this issue to try to provide some clear lines that property appraisers and municipal owners could follow. And I think those lines should stay where they are. I think the line of saying you have to look at how, not only you have to look at how the profit is computed by a private management company to determine whether the use is exclusive or not, is a fuzzy, inartful, difficult to follow test that, as the amicus said, would create chaos among the municipalities throughout the state if that rule is allowed to stand. Thank you.
Thank you, Your Honor. My name is Lauren Levy. I represent Greg Brown, who's the Santa Rosa County Property Appraiser. With me at the council table is Sidney Rodkey. If I could maybe start with the question that was last left with my friend Mr. Fleming. What was meant by the 1968 change? What should be the test? The test should be whenever government, cities, allows a private for-profit business to use city property for that purpose, you must lose the entitlement to the exemption. That is the exact and precise purpose that the 1968 Constitution was amended.
Well, but when you state it that way, you're assuming who is using the property. I mean, I guess that's kind of the core of the issue here, right? The question is the property being used by the city, or is it being used by the management company that the city has contracted with to help run the operation, subject to all sorts of restrictions in the oversight of the city? That's what this is about, right?
I think use ultimately comes down to what the court should look at as maybe opposed to control, Your Honor. But when the city says, I have an asset out here, here's a recreational asset. In Sebring, it was a raceway, which was a recreational asset. When the city says, I have an asset, and I'm going to allow you.
They leased it, and that's what we don't have here.
Your Honor, I realize we don't have a lease here. But the
and throughout it, and am I correct in understanding? I mean, I understand you've got some other things in the case law, but throughout the case law, the focus in these cases tends to be on the fact that there was a lease, and that is a recurring fact pattern in the case law. Isn't that correct?
Yes, Your Honor, and the reason why is because that's how cities interacted with entities that used their property. That was what was going on before the 1968 change. And if the Constitution were amended to say municipally owned property and used exclusively by it shall be exempt from taxation unless the property is leased, well, then we could draw the line at lease versus management agreement. But if I could continue just one moment. If this court were to draw the line at the distinction between a lease and a management agreement, you will eviscerate this constitutional protection, because no prudent city attorney will ever draft another agreement with a private user of government facilities as a lease. They will simply call it an operating agreement, and Article VII, Section 3 will have no more practical purpose or use. That's essentially is what they are urging. They essentially acknowledge, Your Honor, if we leased the property for running a golf course, it would be taxable. This court said so in Capital City. There's other appellate courts that said that. But because we didn't lease it, somehow the Constitution now must be read differently.
But what I'm struggling with here is just trying to draw this back to the words of the Constitution. Because when I look at it, property has to be owned by a municipality, and there's no question here that this is owned by the municipality. So this is all then goes to the phrase used exclusively by it for municipal or public purposes. And it just seems to me that in understanding that, we would ordinarily think of, when we think of the circumstance where there's a leasehold interest, we would think of the property that is subject to that leasehold interest as property that's being used by the leaseholder. Okay? I mean, if, you know, that's just, but if it is property that is being operated pursuant to a management agreement, I think we would ordinarily think of that as property that is being used by the owner that happens to be subject to a management agreement. I mean, because that distinction between the lease and the management agreement seems to me to be quite material. It is a different sort of arrangement that affects the way we would think about who is actually using the property. What am I missing when I say that?
I believe it's a distinction without a difference. I believe the distinction between a management agreement and a lease is not mentioned in the Constitution and should not be the basis for distinguishing the private uses. In fact, when you look at this management agreement, Your Honor, what jumps out at you? Well, the entity that's being hired to manage this property is paying rent. They got all of the responsibilities that you would see in a triple net lease. They got to pay insurance. They got to pay taxes. I agree with counsel whether they got to pay taxes or not doesn't weigh in, but that's a typical earmark or hallmark, if you would, of a triple net lease. And so could you, as a city attorney, the document says lease at the top, you scratch through lease, you write management agreement, and all of a sudden now my property is no longer taxable.
Isn't your recourse in that case exactly what happened here? That is, you sue and you say this really is a lease, and a judge determines whether it is or it isn't a lease. And in this case, because inter alia, the document says on its face it's not a lease and no leasehold interest is transferred, you lost that argument, right? So it isn't this parade of horribles like, oh, we're never going to be able to tax anything because the city attorney is just going to scratch the name. That really doesn't hold up. You'd be able to establish if something was in fact a lease that was masquerading as something else. I mean, the courts aren't closed to that argument, are they?
Your Honor, I believe if you were to say in this case where the entity, the management company, is paying rent and has all of those other obligations, that form of an agreement still would allow the exemption. It would not destroy the exclusively by it. I'm not so sure there would be another management agreement that would fail that test.
I'm glad you've taken us back to exclusively by it, because of course that isn't the end of the sentence. And your friend made the point that in your briefing you sort of over and over and over again sort of omit the rest of the constitutional provision. And I'd like to sort of walk with you through the consequences of that choice. I mean, if your reading is correct, am I right that if someone decided to hire a golf pro at this course to teach them the game of golf, that the property appraiser's position would be that the city has lost its constitutional exemption from ad valorem taxation because the golf course is now being used, at least for a moment, not exclusively by the city? Mm-hmm. So anytime a golf pro is hired, that's enough?
No, sir, I wouldn't believe so.
Help me understand why.
Sure. Let me try to distinguish this way. If the golf pro was given situs within the golf course, that's yours, you get to use that to do golf lessons and nobody else gets to use it, and you get to keep whatever money you get from making those golf lessons, I would say that would be taxable if that were the case.
Okay,
we're setting aside.
So for you, it would have to be an exclusive agreement with the golf pro. But if there are 5 golf pros, then somehow magically the tax exemption is retained?
No, sir. I was trying to explain you would have an exclusive area for the use of that golf pro. Here, this company was allowed to use the golf course, the restaurant, the bar, the pro shop, all that, to generate business profits. It ran the entire course. No other entity was allowed to do the same.
Why should profit matter? Let's change the hypo. Mm-hmm. Let's say there's a charity tournament, a golf scramble, right? The whole course is available annually for this charity tournament. It is being used to raise money for the Gulf Breeze beach renovation project. And we have an agreement that every year, that weekend, the golf course will be used for that purpose, a beneficent purpose, a eleemosynary purpose. Are we now, is the tax exemption now gone?
No, sir, not on an infrequent basis like that, nor would it be if that was the only thing you could do at the golf course, because the Constitution allows the legislature to say such portions of property used for charitable, et cetera, purposes may be exempted, and you would be operating under that provision. And the reason, go back to the 1968 change, the reason I emphasize exclusively by it is because this court has said that is the significant language that changed in 1968. The municipal or public purpose definition did not change. That's the City of Gainesville case and the Treasure Coast case, which was actually a case that I handled. But that definition has not changed. The 1885 Constitution just used the word exclusively. And when the change was made in 1968 to go to exclusively by it, this court, many times over.
But I insist, the rest of the sentence is still there, used by the city for a purpose, right?
I would agree. The rest of the sentence is still there, but that didn't change. The change was exclusively by it so that private users of governmental property are required to pay their fair share of ad valorem taxes. Look at it this way, and the court talks about it in Williams versus Jones and some of the subsequent cases. It's almost like an anti-competitive nature. Why should a business using government property to run its business and generate profits have an advantage over the business?
You keep assuming the whole what's in dispute. And everyone agrees that it doesn't literally mean used exclusively by it. And so we have to come up with some way of understanding what it means. But to get to your point about how everybody would just change the title of their agreement, are you suggesting that every government entity that was leasing over this property or changing the name to management agreement would want to take responsibility for the level of control over the use of the property and what goes on in a way that's present here? Because it seems like we're not just, the question isn't just what's the label on the top, it's the substantive content of the agreement. And I think that the suggestion is that if the city is the one that ultimately is controlling everything that's going on the property and saying how it can be used and this and that and whatever, and every time you want to change something you have to call someone in the city to get permission, that's what distinguishes it from the lease. It's the control factor, not what you call the agreement.
Your Honor, I believe that all governments, if they're going to allow a private company to use their facilities, will want to have some level of control over what that person is doing, whether it's in the terms of a lease. You got to close the park at 10 o'clock, you can't stay open all night, or whether it's pursuant to the terms of a management agreement. All governments are going to have some level of control. What is the level of control here? This company runs the golf course, does the day-to-day operations. It provides a monthly report and an annual report, and the city maintains the right to utilize the irrigation equipment. But the record testimony in that regard was, well, the golf course superintendent determines how much water to put out on the course, and only if the pond is over 8.5 foot would we lean in and say we're going to have to put more water on the course than the golf course superintendent may deem necessary. But the testimony of that person, that's in the deposition of Mr. Prather, was that that had never happened in his time at the golf course. So the level of control that the city was exercising, I don't think it's fair to characterize it as they are there saying on a day-to-day basis what must be done. They required the contractor to have open records or open books, to provide those books to the city, the contractor to deal with customer complaints and various items like that. But when it got down to, well, how is this golf course going to be run on a day-to-day basis, that was the business of the contractor. I don't see where that level of control, Justice, is significantly different than a lease. I don't think a city would simply say, you have the right to lease this property and do anything with it at any hour of the day that you would so choose. And it's certainly not been an element that this court has looked at.
I mean, you're creating or projecting this idea that cities are always going to want to avoid anybody who leases property from them paying a tax, and therefore they're going to do this. Wouldn't there be circumstances, and aren't there circumstances, where a city says, we don't want to mess with this. We're leasing it, you deal with it, you pay the tax. Doesn't that happen?
I believe it does, Your
Okay,
Honor.
well, I would expect so, because they don't want to be involved in it. And so I think this kind of, the specter that you have suggested, I don't think always is going to be the case. And I'm just, and the idea that they're giving it to this management company to use, they have involved from another perspective, which is the city's perspective, is that they involve the management company to help them stop losing money, because they want somebody who knows how to operate it. And not somebody who's going to use it, but somebody who can operate it and reduce the losses that are being suffered. Isn't that another reasonable way of looking at it?
Justice Kennedy, if I may, that was the exact reason proffered in the Sebring Raceway case. The city had operated the Sebring Raceway for years and lost money. They continued to lose money. They wanted to bring in a prudent operator.
Well, and they leased it.
And they leased it, yes, sir. And their argument would be, if that were a management agreement, then this court should have reached a different decision. And I don't believe the Constitution should be read in such a fashion. It certainly is not evident in the language of the Constitution. And the courts...
But your friend answers that it is evident. It's evident in the first part of the provision. It's, in a limited sense, ownership has changed, right? You don't own all of the sticks in the bundle when you lease something. The tenant has, for example, a right of quiet enjoyment, all sorts of different rights that attach to a leasehold interest. And so maybe focusing less on the second part of the sentence and on the very beginning of the sentence, the argument would be that if I have transferred a leasehold interest, I don't own the property outright. I own it subject to that leasehold interest. Isn't that a way to square this court's jurisprudence on leases with the text of the Constitution?
Yes, but it would not be appropriate to say a management agreement is somehow different, Your Honor. It's basically the same thing. This company had the right to run this golf course and try to maximize profits as best as it saw capable of doing, Your Honor. It had the right to do that. No other company could do it. Nobody else could come in and say, well, I want to run it today. The city only could come in and do it if the contractor was not living up to its obligations. And in effect, the city had transferred part of its, if you want to say, bundle of rights. This was a 7-year deal with 2 5-year options that the city agreed. The city agreed that if we should sell it during that time period, you'll have the right of first refusal. And so you can make the decision whether you want to stay or not. And the city could not turn around and decide, well, we want to now lease it to somebody else under that. We don't have the ability to continue to run the golf course itself. And if the city could have run the golf course profitably, that would be profits that would go into the city's budget. So I don't see a material difference in characterizing the agreement with a private entity as a management agreement or an operating agreement or a lease, Your Honor. I don't believe it makes a constitutional difference. And if it were, then yes, we would look at, is this management agreement really a lease? And if this one is not, then none is.
It wouldn't be different if there was just a fixed fee for the management company? Say they're paid, X dollars a year, and that would that not change your view of the way this should be handled?
Your Honor, it certainly takes it a step away from acting more and functioning more like a lease, okay? Because a lease, you get to use the property to generate what profits you can. Here, the management agreement was the same. And I think the First District Court, when they pointed that out, they were trying to answer just the question, and as much of the question in front of them as they needed to. I'm the practitioner in this area. I would like the court to say it doesn't matter whether the use is pursuant to a lease or a management agreement. That's a more expansive decision. It functions
well, you're
a lot.
representing Mr. Brown. I understand.
Right. Well, it functions.
Mr. Brown's won a few of these cases, right?
Yeah, yes, sir. He certainly has, and my office has been involved in a lot of other cases in this area. And it does appear to us, when you look at the history of how we got to where we were at, that the Constitution was changed intentionally in 1968 so that private operators on government property should have to pay ad valorem taxes just like the folks they compete with. If I could make one final comment.
Well, let me ask you, though, just to close the loop here. So you think that the earlier first DCA case that it said that the flat fee management agreement didn't change the tax status, was that wrong?
I'm sorry, I didn't quite follow you.
Wasn't there an earlier case where there was a flat fee and the court said that didn't that didn't affect the tax exemption, and now the first DCA seemed to think that the changing the nature of the compensation was relevant to the tax status. Do you disagree with that?
So in Zengali, the First District Court pointed out that the golf course was operated for a nonprofit basis, and there was a management company involved in there, but this court didn't look at that on appeal, and it didn't approve it in the Treasure Coast decision. And if I could just have one second, please, Your Honor. The 1968 change seems like that's a long time ago. In 1978 and 1998, the voters of the state of Florida were asked to amend this very provision and amend it in a way that would allow the exemption under these circumstances. And the voters both times voted it down. This court in Sebring acknowledged that that was the paramount public purpose that we should be looking at, and we would ask that you affirm the District Court of Appeals decision and answer the certified question in the negative. Thank you very much.
Used by and managed by are different terms. Every private management company could be deemed to use whatever property they're managed. They could be deemed to use it. If that destroys the immunity, then it's destroyed for all private management companies. As the League of Cities points out in their amicus brief, is that hiring professionals to manage city services is a growing trend. Why? Because professionals managing services tend to do a better job. What do the facts in this case show? The city managing these properties with its own staff lost money year after year after year. Their primary goal was to stop losing money. They wrote this management agreement very favorable to the taxpayers of Gulf Breeze. I'm not sure I would have signed it if I'd been the management company or recommended it if I'd been the lawyer, but very favorable to the taxpayers that stopped the losses. The management company did exactly what the city told it to do, what the city wanted it to do, and the uses of the properties remained unchanged. The only thing that changed is the city wasn't losing money every year in the management of these companies. So do we want to discourage that as a matter of public policy? I would think not. I would think that's an issue that we don't want to discourage, and no court has done that. No court has done that.
You know, there was something I meant to ask you earlier and failed to. The golf course is outside municipal lines, is that right? It's not in the city. Is there any relevance to that fact given the second sentence of Section A to our analysis, or is that just not at issue here because there isn't a general law requiring taxation on the property?
It's not an issue, and the courts have looked at the fact that, for instance, transmission lines conveying electricity may be on property that's not owned by the governmental entity that's providing the power, but that doesn't matter. It's how the property is being used. In this particular case, you know, the facts show that before the city even purchased this property, it was using it as a spray field. The facts show that when they were using it as a spray field, they were constantly having a fight with the golf course because the golf course saying, our fields are saturated. It's been raining a lot, and therefore don't put any more brown water on our fields. We have to. We don't have anything else to do with it. We have to do that. And so there was constant battle. So when the golf course came up for sale, the city said, we need it for our brown water spray field. Let's buy it. Was there intent to make a profit? No. Was there intent for the management company to make a profit? No. Their intent was to have a reliable place to dispose of their brown water and the ancillary use of recreation for the citizens. In the case where a marina is used by both residents of the jurisdiction and non-residents of the jurisdiction, is still deemed to be a public purpose. So there was no question in this case, Your Honor, that the use of this property for a golf course was a public purpose. The court below said that, and the property appraiser never challenged that. In fact, the property appraiser year after year after year granted the immunity for this property based on the provision of the Constitution granting immunity, and it changed it when and only when there was a management agreement, which it claimed was in reality a lease. The argument that everyone would just change the names on leases to management agreement is disingenuous for the simple reason that the court can look to the form of a document. In fact, a case that Mr. Brown successfully handled before this court was the Navarre Beach tax cases in which the documents were called leases. But this court found that they were, because they were perpetual leases, actually conveyances, because the property never came back to the owner, who was a county who was immune from ad valorem taxation. Thank you.
Thank you. We're going to take a short break, and we'll be back for the last two cases.
All right.